As panelists have said a few times today, government regulation is a piece of this complicated puzzle. So I'm pleased to kick off this next panel by introducing Prabhat Agarwal and Gerard de Graaf, the head of unit for e-commerce and platforms and the director for digital transformation, respectively, at the European Commission's DG Connect. Many of you have heard about the European Union's Digital Services Act, or the DSA, which is the EU's attempt to put forward a rights-respecting and democratically informed approach to platform governance. We're in for a treat because Prabhat and Gerard are the foundational drafters of this landmark regulation. I don't think I'm saying anything controversial when I note that here in the United States, home to many of the world's largest platforms, we have yet to have a cogent national level conversation about regulation. In the void, all sorts of countries around the world and even states within the US are driving the conversation and setting the rules of the road. And many of these approaches are anything but democratic. So this DSA is more than just an EU regulation. It's a potential model and the only fulsome democratic standard with which to engage at the moment. I'm going to pass it over to Prabhat and Gerard to give a short presentation on what exactly the DSA is and what it's trying to accomplish. And then we'll come back for a conversation, including questions from those of you watching at home, to dig in a bit more about what the DSA could mean for democracies globally. So with that, Prabhat and Gerard, thank you so much for joining us today.
Good afternoon, we're evening in Brussels. It's a pleasure to be hosted by you. We're very much looking forward to an interesting discussion on the Digital Services Act. I think one thing is clear, we're as policymakers, as kind of government officials, as interested observers, I think we're all looking at what role these digital intermediaries, these platforms play in our lives and how they should be kind of governed and to make sure that kind of the internet remains a pluralistic and safe place to engage and to do business on. We prepared a few slides. The debate is ongoing in Europe. We're negotiating now on the Digital Services Act in the European Parliament and in the Council. So it's very timely now to have this debate. I will take a few of those slides and then Prabhat will take over, and very much looking forward then to questions and answers. Well, the first slide is just the title slide, so maybe we could move to the next slide. This is a very simple and actually, obvious slide, and it says the world has changed. When we first regulated, and it's still the regulatory framework in the European Union is called the Electronic Commerce Directive, which was adopted in 2000, so 20 years ago, and has been around for that long. And the world has changed. I mean, a lot of, say, the activities that we know now were not around, say, when we were designing the e-commerce directive. Platforms have become much more important to our lives in terms of social media, in terms of marketplaces. They are also very important vehicles for small businesses in Europe, medium-sized businesses, to reach their customers. So it is timely now to look at that framework in the European Union and to decide like what can still be maintained, what has worked well, but also how can it be updated. Maybe we can take a look at the next slide. Altogether, there's less than 10 slides. The next slide, I think what is the main message there is this isn't just about large platforms. I mean, obviously we often are kind of say focused on, well, what about Facebook, what about Google and YouTube? But in Europe, we have 10,000 platforms. Most of them are small. You will probably not have heard of many of them. You probably know Spotify, maybe you know Zalando, there may be a few others you've heard of, but the large majority are very small. We, of course, if you look at, say, the big five platforms, they're very large, not just large as platforms, but large if you compare it like they are kind of about a quarter of the EU economy as a whole. So they're very, very big, very, very powerful companies. But what, of course, the ambition is of the European Union, and that comes back into the objectives, is that we want also in Europe platforms to grow and to be successful and develop into European and where possible globally successful companies. Go to the next slide. Well, these are the objectives, and actually one of the objectives that I should highlight, and it comes from the previous slide, is that it's difficult to scale in Europe because Europe is fragmented. The rules are not the same. We have 27 member states. They have different rules and regulations, and therefore if you're a successful small platform in one of our member states and you want to scale up. You need to go to other member states. You need to adjust your business model. You need to check out what are the rules that apply to me. And that slows you down. And the internet is all about scale and speed. So before you actually reach the scale and speed, it takes a long time. For example, Spotify, how did it grow? It started in Europe, it went to the US, it got scale in the US, and then it came back to Europe and it completed its coverage in Europe. So the digital single market, one set of rules for the whole of the European Union, is a critical objective. But obviously also, we need to modernize the rules. We are dealing with very challenging societal issues about illegal content, systemic risk in the online space. We need to make sure that kind of the internet remains a safe space, that there isn't room for illegal content, there isn't room for dangerous products, unsafe products on our marketplaces. We need to clarify some of the rules, for example, on liability. We need to make sure that kind of the liability works well. That in Europe, companies are exempted from liability, even if they have actual knowledge, so that they have information that there's something illegal on their services, on their platforms, and they act expeditiously. And so that principle is very solid. We intend to maintain it, but it needs to be kind of clarified a bit how it should work in the future. And last but not least, we need to kind of make platforms more accountable. We need more transparency. We need better cooperation between competent authorities. We need better oversight. We'll give you in a minute kind of insights in how we will do that. Let's turn to the next slide before then Prabhat takes over. Well, this is a bit kind of the difference between the e-commerce directive, which is not going away. We maintain it, we build on it. So what do we build on the e-commerce directive? Well, essentially, we build what we call due diligence obligations, which is in the right-hand column. So we are going to define, or we're defining in the Digital Services Act, responsibilities that platforms will have to comply with, depending on their size. So it's an asymmetric obligation. If you're very large, very big, you need to carry greater responsibilities compared to if you are small. If you are in a very much kind of a user consumer facing position, like a social media company, you have greater responsibilities than if you're like more a hosting service in the European Union. So these due diligence obligations are the hard core of the Digital Services Act, and we'll identify some of them in the next slide. We also need to work more closely together between the member states. And this is the complexity of the European Union. We are different countries, so these different countries need to work together. The rules that apply to platforms are the rules in the country of establishment. Most of the cases it's Ireland or Luxembourg. But of course, the countries that are so-called countries of destination need to be very actively involved. So we have got some innovative ideas how to improve the governance and the supervision of these platforms, large and small in the European Union. I hand over to Prabhat.
Thank you, Gerard. It's a pleasure to be here this afternoon. We can go to the next slide, and I only have a few more slides to take you through the basic architecture of the Digital Services Act, just following on from what Gerard has just told us. I think one of the key elements is that we've designed the Digital Services Act to be differentiated according to the role and the size that a particular intermediary service has in the online economy. So we have a cascade of rules, and the cascade of rules starts from what you may call infrastructure intermediaries. So they really are the access providers and domain name registries or kind of Wi-Fi connection points, and then we scale up the architecture of the DSA with additional due diligence obligations. First, for hosting services, those are kind of cloud infrastructure and web hosting services. They are actually the category that was originally regulated in Europe back 20 years ago. And we've added two new categories, online platforms. That includes marketplaces or app stores, or what we call in Europe collaborative economy platforms, in the US, sometimes known as gig economy platforms, but also social media services. And then we have in this identified a particular category of what we call very large online platforms. And those are the ones that reach more than 10% of EU population through their users. And those are the ones that are then subject to the most comprehensive catalog of obligations. Now, before, in the next slide, I will show you the catalog and give you some flavor of the different obligations that we've imposed. I just want to stress one thing is that it's not only about obligations and due diligence. Of course, this is the novelty of the Digital Services Act, but we also have maintained the immunization from third-party content that is similar to Section 230 in the US. Although I want to say right at the outset that in the EU, the immunity is not as broad as it is in Section 230. It's more conditional, like what Gerard already alluded to. It has a so-called knowledge standard. This may sound a bit abstract and weird, but it is actually something that is tried and tested and has been tested in court for 20 years. And there's a lot of experience with this, and we've basically maintained this. But there's also, and coming back to what Rose said in the introduction, there are a lot of rights protecting elements in this. So it's not only about due diligence obligations, about due process obligations, about transparency obligations, about also transparency towards, for example, government orders for content takedowns as well. So on the next slide, I can only give you a quick snapshot. It's probably too small for you to read unless you zoom into this. So you see again horizontally the four big categories of intermediaries that we have. Very large online platforms has the most extensive catalog, and infrastructure intermediaries on the right-hand side, they have a very limited catalog, but still very important. For example, we have some obligations that terms and conditions must be rights respecting. They must be diligently applied. So this is in response to an observation and evidence that there's some degree of arbitrariness in the way that terms and conditions are sometimes implemented and changed. There are basic rules on transparency reporting for all intermediaries across the board, which we think is very important to know what's going on. And then there are some obligations which will be familiar to you. Notice an action mechanisms very similar to what in the US is the DMCA a procedure for copyright, but we've designed it to cover all types of content in the European Union. There are other types of content which are illegal. For example, child sexual abuse material is a content that's illegal across the board. And then we have a whole range, and I won't go into all the details, but maybe the two elements that I want to highlight is on the bottom left corner. For the very large online platforms, we have a new obligation for systemic risk assessments. And that also captures issues of disinformation and election manipulation. And we have a very wide-ranging catalog of obligations on data access and transparency for recommender systems, transparency for advertising systems. And so the main message on this slide is that not only is there a big catalog of obligations, particularly for the large ones, which we believe captures the majority of emerging issues that we have at the moment, and we'll come to the next slide. The DSA is also going to have laid very solid foundations on the rights protecting elements that we have we think are really important there. So on the next slide, if we just we just a brief word about the governance structures. This is also relatively new. There will be independent authorities in member states supervising the Digital Services Act. They come together in a kind of board for digital services, and they can give guidance as well on emerging issues. This is something that at the moment is missing. And the Commission also has direct enforcement powers as well. And just on my last slide, I want to just highlight some of the benefits, and I won't blow you away, because I think we're more interested in the details of the discussions that we will have right now. But one of the key points that I want to highlight is that I think we've designed the Digital Services Act to help users, end users, and they should have choice online. They should be safe online, and the user rights should be respected, particularly freedom of expression online. This has been a guiding principle of our design. At the same time, authorities do get new powers, including sanctions, and I didn't mention that. But what is the most interesting part of the DSA for me is that the DSA will generate a huge amount of regulatory data for the public for the purpose of public supervision. And I think this is a really interesting way, because we try to regulate the data economy also by generating data through data. Independent researchers have a specific role in looking at what's happening on the platforms as well. But platforms also benefit from a single set of rules across the European Union. So with that, I stop here. This is the last slide. I'm just slightly over time. And Rose, back to you for hopefully a great discussion.
Thank you so much. That was excellent. I think maybe a softball to start us off, which is just if you can speak a little bit about the process that brought us to this point. What did the drafting look like? Who did you speak to? What are the consultations like? And where does it go from here? Is this locked in, or are there opportunities for members of the community to provide input? How do things get changed over time?
I can start. I can kick this off. I think we're actually, the design process of the European Commission is, we're quite proud of it. And so this is, first of all, this work has been not done just in a short period of time, but it's building on almost a decade of experience with online platforms and many self and co-regulatory processes that we've been carrying out, whether it's on disinformation, on hate speech online, on unsafe products, and so on. We've been running many collaborative projects with online platforms, and the Digital Services Act is really informed and actually builds on that experience. It also builds on some experience in national laws, like maybe some of the audience have heard about German proposals on the NetzDG and so on. So we've taken, I think, the best of that into the DSA. There's been a long public consultation with more than 3,000 contributions. We've had more than 250 meetings with different stakeholders or interested parties in the preparations, and extensively consulted also with the European Parliament in the run-up to that. And now in December 2020, we proposed the draft law, and now it is in discussion with the European Parliament and the European Council. That's where the member states come together. And so they are discussing and amending the Commission's proposal at the moment. This is an ongoing process. We expect that both of these other institutions, the Parliament and the Council of the European Union, will come to their positions at the end of the year. And then hopefully the expectations are that early in the first half of next year, the law will be adopted. So still at this moment, there is some fluidity, Rose. And so I think parliamentarians in particular are debating the best way forward, and this is an ongoing legislative process.
Thank you. And I assume some in our audience are familiar with a bunch of acronyms floating around right now. There's the Digital Markets Act. They may already be familiar with the European Data Protection regulation, as well as the EU Democracy Action Plan and other things. Can you give us just a little bit of sense of how these things fit together, as well as what is the DSA not? Where does it stop? What are you not trying to do with the DSA?
Well, I can maybe give an answer here. I mean, the DSA was proposed at the same time as the DMA, the Digital Markets Act. Both came out in December. The Digital Services Act is very much about responsibility. It's about keeping the internet safe and ensuring that our values in the European Union and our freedom of speech, our fundamental rights, are adequately protected. So that's the kind of the objective, the vision behind the Digital Services Act, and of course to make sure that our digital single market can work well. The Digital Markets Act focuses on what we call contestability, so competition in the market. I mean, we are, of course, dealing with some very powerful platforms that in some cases are so powerful that they can set the rules of the game. And since a lot of kind of other companies and users depend on these platforms, it is in the interest that competition works as effectively as possible. So that's the Digital Markets Act, where we identify a number of practices which we could call unfair. And therefore, these practices will, after adoption of the Digital Markets Act, no longer be allowed. For example, self-preferencing. So those are that's the package of measures that are now going through the legislative process in the European Parliament and in the Council of the European Union. The GDPR has been around for some time, 4 or 5 years now. And of course, before that, there was the Data Protection Directive. This is, I think, quite well known in the US. And of course, there are interlinkages. We talk about the data economy and therefore data. Platforms use often data in order to, of course, for example, target their advertising or to gain competitive advantages. So that read across with the GDPR is very important. We have other measures out as well. So there's a whole set of measures, but the Digital Services Act and the Digital Markets Act are definitely, say, the most important measures at the moment that are under negotiation in the European Union.
Thank you so much.
Just add.
Oh, yes, by all means, jump in.
Just to answer your question, Rose, what the Digital Services Act is not. It's not an instrument to tell people what can be said and what cannot be said online. It's not an instrument for authoritarian regimes to dictate how people can express themselves online. This is for sure something that it is not. It's also not the Ministry of Truth when it comes to disinformation or those related problems, and that's very important to say. So it's not per se regulating what can be said online, but an analogy that I sometimes use that it is regulating the fire exits, the alarm buttons, all the safety features that we would expect if you go to a shopping mall or to a concert hall. But it's not saying anything about what can be said and what cannot be said online.
Excellent. I wanted to turn to one of the more specific elements, and I think in a bit we're going to hopefully be able to talk about transparency. But on the question of liability and enforcement, if you could share a little bit about how that is going to work. There's obviously some penalties that are built in. There are a lot of questions that people have around the role of courts in enforcing violations. So could you give us a sense of what that looks like, as well as what some of the protections are to guard against political interference in the enforcement of the regulation?
Sure. Excellent question. So, of course, courts are in the European Union the ultimate arbiter of what is illegal online and what is not illegal. This is something that ultimately has to be established by courts. And also in the European Union, we have the Charter of Fundamental Rights, and access to judicial remedy is always a fundamental right and needs to be guaranteed at all times and independent of any of the procedural rules that we have. What we have put in terms of safeguards, let me start with that, into the Digital Services Act, a lot of processes in parallel. First of all, knowing the rules of the game. This is the transparency obligation on terms and conditions for what can be said on your platform. Say it up front. So say, and then be diligent in enforcing that. That's a first safeguard, and it's empowering users to know what the house rules are. Then we have a whole range of safeguards against erroneous or excessive takedowns. There's an internal complaint mechanism. There's an out-of-court dispute settlement system. There are ways that you can always go to court. There are ways that you can raise complaints individually to your national authorities. You can also, civil rights organizations can take collective actions. So this is just to give you some flavor of some of the safeguards that we have in the Digital Services Act. I think the roles of courts is very important, and it's also recognized in the Digital Services Act. For example, one way that we have of dealing with illegal content, such as child sexual abuse material or other types of illegalities in the European Union, is by courts to send injunctions. And these are very interesting tools. These are typically no-fault injunctions. They get sent to an intermediary saying this has to be, and this a court establishes that something is illegal, and it has to be taken down based on and we've got some rules and clarifying, for example, what the territorial scope of such an injunction should be, how precise it should be, and that's put into the Digital Services Act. So we think this is the role of courts is very important. And it's fully recognized in the Digital Services Act. So just to give you a little bit of a flavor of some of the safeguards we've put in place.
I may, Rose, I think what is important is that we take a systemic approach here. I mean, in the EU, we often compare kind of the supervision of like the platforms to the supervision of banks, insurance companies. And so you want the systems to be sound. Are there going to be mistakes? Are there going to be kind of illegal conduct? Yes. I mean, this is not going to be a 100% kind of foolproof mechanism, but you will see in some of the due diligence obligations that we are really focusing on this systemic. I mean, and some of the terms of fit and proper, know your business customer, risk management, independent audits actually are kind of have been borrowed from the world of banking into this world. So we do not define in the Digital Services Act what is illegal and what is not illegal. That is defined in other pieces of European law, and in some cases where we don't have like European definitions of illegal, it's defined at the member states level. So this is very much about systems and processes and checks and balances to be put in place. And I think it's important to have that perspective in mind.
Thank you. Before we move on to transparency, I just want to come back to the question, however, of political interference. I think in the human rights community, there are a lot of concerns over some anti-democratic trends in some EU member nations. And so how do you think about the boundaries in that systemic approach to ensure that a nation is not able to go after a platform or go after speech on a platform for their own political reasons or with the intention of shuttering civic space?
And it's a tough question, Rose, and we've stress tested the DSA against some of these scenarios. But of course, you know, a feature of authoritarian regimes is typically also, or autocratic regimes, is that they're not rights respecting in the first place. So there are safeguards built in, notably actually helping users to raise issues. There are safeguards in the board structure where national coordinators come together and exercise a degree of peer review and peer control over each other. The role of the European Commission as the guardian of the treaties is enhanced and can step in certain circumstances, particularly in a very large online platforms regime. The role of civil society is strong in the Digital Services Act in various, either in intervening in the collective interests of users. So if, for example, a platform is subject to kind of large-scale bans or speech controls, then the civil society has new rights and empowerments to take issues to court on behalf of a collective representation. Those are some of the instruments that we have put in. Of course, member states and the European Commission and all European institutions are bound by the Charter of Fundamental Rights. This needs to be respected, and the European Commission is at the moment very active in defending the Charter. And I think that we expect that also this will continue to be the case going forward, and it's kind of the bedrock on which the Digital Services Act will sit, if I may say so.
When enforcement in a way is mutualized, there is no possibility for a single member state in the European Union to dictate to a platform what it should or should not do. If the member state in the country of origin disagrees, no action will be taken, and then it will be kind of raised to the level of the European Union. So the system is full of checks and balances. It is going to be very difficult for a single member state. I mean, we live under the rule of law, so let's not give the wrong impression to the US that kind of, we have kind of major problem. We have some issues with kind of some regimes in the European Union, but the system has been well thought through to make sure that, it cannot be abused by those who want to suppress like freedom of speech.
Maybe I can just add one element which I think is really also strong in the Digital Services Act, and I don't want to blow my own trumpet too much, but it's the public accountability of what's going on. Excessive government takedown will lead to a data trace that's public, and it can lead to scrutiny about what's going on. And I think it's this kind of scrutiny that we don't have at the moment. Although some companies are publishing voluntary transparency reports, they're partial. They don't have detailed geographic coverage. Timestamps are not available. But this kind of public accountability also to say for the whole world to know what's going on, this kind of data is going to be generated. So if it is abused by some authority, well, it'll leave a trace, and it'll leave an unmistakable trace, and that should be also a route on which further action can be taken by all actors in society, not just a rule of law, which we, as Gerard said, is very important for us.
Thank you. That's actually a great segue to what I want to make sure we cover with just a few minutes left, which is we're at a conference that's a gathering of the world's open source researchers. And so there's a lot of excitement about the transparency provisions within the regulation as it's currently written, as well as some questions. And so one to start with is, if you can, I'll pile two in a row. One is, I think a lot of people are focused on the limitation of academic institutions as the as a requirement for having access to the data that you're requiring platforms quite excitedly to have to start providing. Are there opportunities for organizations like DFR Lab or the other independent researchers around the world to be able to access that? And then the second thing is just if you can speak a bit to what it is that you think, particularly in that space, the US and the EU can collaborate on, and the global community dedicated to human rights can collaborate on, as you push forward this major experiment in shaping the governance of technology. Those are, tiny questions for you in the last few minutes.
I'll take the easy one, the first one, and I'll let Gerard take the second one, which is exciting actually, and I'll be very brief. I think the perimeter to academic institutions is being discussed right now. I mean, it's something that has been raised from various points. I think our key message on the definition of academic research is that there needs to be some kind of boundary about who has access. I mean, it's not reasonable to give access to everyone to the platform data. There needs to be some criteria, and they are spelled out. Whether then the definition of academic institutions in the DSA is the right one or not, I think this is something that's still being debated.
Thank you.
On the second question, I mean, as you know, I mean, last week at the summit here in Brussels, the EU and the US agreed to launch a Trade and Technology Council, where this issue of platform kind of regulation, technology platform regulation, will be very prominent. So we're very much looking forward to working with the US government and of course the stakeholders to develop common approaches, because I think it's really important that the EU and the US, in this world where indeed there are autocratic regimes that are kind of restricting freedom of speech, are using technology to take away freedoms, or to keep people kind of really in kind of under surveillance, that we as the US and the EU, with our democratic societies, our values, we offer a positive alternative model to this. So that I think is really important. And then we would really like to see where we can more closely cooperate on certain issues, maybe around access to the data, as we just discussed, maybe on notice and action. So we're going to engage very shortly with the US administration, and I will also recommend that everybody kind of contributes their views, where the EU and the US can make most progress in the next, say, couple of months on these issues. But it's really a great opportunity to work together.
Thank you both so much for taking the time. I could talk to you for probably another hour, and I'm sure our audience has many more questions, but we're so grateful for the time that we got, and very much look forward to continuing to work with you, and invite, as you mentioned, the entire community present, watching here, following us online, to closely follow and feed into this exciting opportunity to try a different way forward. Thank you both very much.